Federal College of Education, Obodo. My Lord, the parties are absent.
Appearance.
If it please my Lord, may GEOT announce his humble appearance for the claimant. We sincerely apologize for the absence of the claimant, my Lord.
You are welcome. Yes, any other appearance?
Yes.
May it please this honorable court.
Okay.
T.O. Inyambe, Senior State Counsel 2, Cross River State Ministry of Justice. With me is you.
Wait, Senior State Counsel?
Yes, my Lord. Senior State Counsel 2.
Okay. You appear
Cross River
with
State
who?
Ministry of Justice. With me is UK Okpan. Okpan is OKPAN. State Counsel
Yes.
2, my Lord.
Okay.
Our humble appearance is for the first defendant.
Okay. Any other appearance?
Yes, my Lord, sir.
Yes.
R.O.S. Ogbeche.
R.O.S. Ogbeche.
Yes, with me, sir, is my learned friend, T.O.O.D. Esquire.
D.O.O.D.
O.D. Yes, my Lord. For the second, third, and fourth defendants. My Lord, we apologize for the absence of the defendants.
It's all right. This matter is for judgment. The judgment of the court is ready. But before I proceed, let us agree. Do you want me to read everything or to read only the portion of the judgment?
My Lord, from the second, third, and fourth defendants, we want the portion of the judgment, sir.
Okay.
My noble Lord, from the
Yes.
claimants, we want the portion of the judgment, my Lord.
Okay.
My Lord, the
Mr.
first
Inyabe?
defendant wants a portion of the judgment, my Lord.
It's all right.
Thank you, my
So
Lord.
I will skip all the preliminaries. I go straight to the decision of the court.
As the court pleases.
As the court pleases.
Okay. Yes, I'm trying to scroll to the portion of the decision. I'm scrolling. Yes, this is the decision of the court. I have carefully perused the processes filed in this suit by the parties, the evidence adduced at the trial, as well as the written and oral submissions of counsel. The crux of the part leading to the institution of this case are simple and straightforward and not much dispute. The claimant was employed by the first defendant on salary grade level 5, step 1, as a classroom teacher in 2003. After his graduation from the second defendant in 1999/2000, see Exhibit C5. The claimant, as at 2016, was earning salary grade level 9, step 8, receiving the net salary in the sum of 63,028 naira 62 kobo. See Exhibit C1 and 2. In 2017, the first defendant carried out a staff screening exercise to ascertain, among other things, authenticity of credentials of their teaching staff. Consequently, the first defendant wrote to the second defendant by the Exhibit D1, letter forwarding 36 names of staff, requesting for confirmation of the authenticity of their result. In its response, as contained in Exhibit D2, the second defendant confirmed the result of 17 staff as genuine, while 19 result of 19 staff were tagged as forged. See Exhibit D1 and D2 respectively. The first dependent acted on the reply from the second dependent and demoted the claimant to salary grade level 4, step 5 from salary grade level 9. However, upon being demoted based on the reply of the second dependent on the authenticity of his result, the claimant complained to the second dependent about his demotion, as a result of which the second respondent ordered for an inquiry to be made. Upon conduct of the inquiry, it was discovered that the claimant results was not forged. Consequently, another letter was written by the first dependent intimating this by the second dependent, intimating the second dependent on the authenticity of the claimant result. Despite several letters written by the second dependent to the first dependent confirming the authenticity of the claimant's result, the dependent failed and refused to act on the letters from the second dependent stating the correct position of the claimant's result. See Exhibit D3, D4, D5, and D7. The first dependent did not deem it necessary to file any defense to the claimant's action, while the second to fourth dependent filed defense attributing declaration of the claimant result as forged due to oversight of approved supplementary result of 1999/2000 year graduation. The oversight arose as claimant was supposed to graduate in 1997, but in 1997, but had several carryovers courses. This put his name in the supplementary list of 1999/98. This also affected the number in his statement of result, which led to the error of declaring his statement of result forged. This, according to the counsel, was admitted by the claimant under cross-examination. According to the defendants, the error of declaring claimant's result is a mistake of the head and not that of the heart, not because of negligence as to be considered as breach of duty of care, as admitted by the claimant in his statement of material fact, paragraph 14 and Exhibit C9 refers to in support. Counsel submitted because of the claimant's claim and testimony, as well as Exhibit C9, the declaration of claimant result as forged is not due to negligence, but due to error of judgment that any reasonable man is susceptible to make. The claimant has argued that he is entitled to judgment and grant of his relief as he has discharged the burden of proof, more particularly when the first defendant has not filed any defense and he is deemed to have admitted the case of the claimant. The first defendant, on its part, has argued that taking into consideration the reliefs being sought by the claimant, which are declaratory in nature, which requires proof by cogent, credible evidence, and not admission or failure to file defense, the claimant has not discharged the burden imposed on him by the law to entitle him to the relief sought. The first defendant asked the court to dismiss the claim of the claimant against it. For the second to fourth defendants, they insisted that they were not negligent in handling or declaring the result of the claimant forged, as that was as a result of claimants having carryovers courses which did not allow him to graduate in 1997 and 1998, there he was supposed to graduate. The second to fourth defendant have also argued that this court lacked jurisdiction to entertain this suit. The claimant has instituted this action to seek for restoration of his position and payment of balance of his salary due to the shortfall occasioned by his demotion. In my view, the issue that called for resolution in this case is whether the claimant has proved entitlement to any of the relief sought. However, before delving into the main issue for determination, I shall first and foremost determine issue of jurisdiction raised by the second to fourth defendant in this case. In arguing issue of jurisdiction, ROS of Beche Esquire, counsel for the second to fourth defendant submitted that this court does not have jurisdiction to adjudicate upon the claims endorsed against the second to fourth defendant in the complaint. It is submitted that this court was created by Section 7 of the National Industrial Code Act 2006 and Section 254C1 of the Constitution. For this court to have jurisdiction, the claim has to be labor-related, employer-employee, According to counsel for the endorsement on the complaint, this is not the case in which second to fourth defendants should be made parties or can be seen from the endorsement on the complaint. Only claim number 1 and 2 concern the second to fourth defendant. It is submitted given the first defendant false and tainted information to the first defendant are not labor related and not covered by jurisdiction of this court as provided in section 254C1 of the Constitution. The only relationship between the claimant and defendant is that he was former student of the college. The relationship is not labor related or that of employer-employee, and this is not covered by the jurisdiction of this court. It is submission of counsel that the issues claim raised against the second to fourth defendant not being a labor one of employee or that of employer-employee deprives this court of the jurisdiction to entertain this suit. Counsel asked the court to strike out the case against the second to third to fourth defendant due to absence of jurisdiction, as you cannot put something on nothing and expect it to stand. For the claimant, it is submitted that the causal connection of the demotion was the sole act of the second to fourth defendant through their reply to Exhibit D1 by their Exhibit D2. By their Exhibit D2, the second to fourth defendant was the Achille heels of the albatross to the exercise leading to the demotion of the claimant from salary grade level 9, step 8 to salary grade level 4, step 5, and from salary in the sum of 63,028 naira 62 kobo only down to 17,496 naira 96 naira 86 kobo. The second to fourth defendant respond in paragraphs 4, 2, 5, 6, 7, 8, 9, 10, 13, 16 of the joint statement of defense are admission and passing back on to the first defendant. They are admitted, however, to be originators of the impasse, that is the cause of action before this court. Establishing the causal connection is the cause of action before this court. Establishing the causal connection is clear without any equivocation. Makes the second to fourth necessary parties and their presence signing conform to the constitution of this suit. Reliance was placed on MBA versus Kende and Oburun and others versus PDP and others. It is clear to me the counsel for the second to fourth defendant argument or lack of jurisdiction is predicated on the employer-employee relationship. This assumption is based on great misconception of the law. This court has power even over persons who do not have any employer-employee relationships. What matters is the subject matter that is being ventilated before the court. In any event, in law, jurisdiction is conferred by the law establishing the court in question and the Constitution. The National Industrial Court, being creator of statute, and the Constitution had its jurisdiction delineated by the statute establishing the court and the Constitution. To successfully determine whether the National Industrial Court has jurisdiction to entertain the matter, recourse has to be made to the provisions of the Act and the Constitution. See Section 7, subsection 1 of the National Industrial Code Act and Section 254C of the Constitution, where the jurisdiction of the court was plainly stated. By the detail of the provisions of Section 254 of the Constitution as amended, the court is conferred with exclusive jurisdiction to exercise to the exclusion of any other court in civil matters relating to or connected with labor, employment, trade union, industrial relation, and matters arising from workplace, the condition of service, including health, safety, welfare of labor, of employee, workers, and matters incidental thereto or connected therewith, relating to connected or arising from the Factories Act, this Trade Dispute, Trade Union Act, Labor and Employment Compensation Act, or any other act or law relating to labor, employment, industrial relation, or any other enactment replacing the act's laws relating to or connected to dispute arising from payment or non-payment of salaries, wages, pension, gratuities, allowances, benefit, and any other entitlement of employee, worker, political or public office holders, judicial office, or any civil or public servant in any part of the Federation, and matters incidental thereto. The provisions of Section 254C of the Constitution has in no doubt clothed this court with bias to entertain inter alia civil cases and matters relating to or connected to labor and employment. This is more evidence from its opening with which deploys the omnipotent word notwithstanding, which in legal parlance is an expression or term of exclusion, which cannot, in spite of, irrespective of, or regarding whatever is contained in other sections. See the Council of Federal Polytechnic Movie versus Dingoli. See also INSA versus Akwaji. In the case at hand, the main facts of this case centers on the motion of the claimant, which was as a result of the response of the second defendant as contained in Exhibit C2, tagging the result of the claimant as forged. I am of the view that determination of propriety or otherwise of Exhibit D2, which was used to demote the claimant, is issue relating to employment dispute within the purview of Section 254C of the Constitution. It is also a dispute within the purview of issue of salaries of the claimant. Therefore, the suit of the claimant is covered by the extant constitutional provisions comparing jurisdiction of this court. It is to be noted that the provision of Section 254C1 as amended has brought all aspects of employment and labor relations within the jurisdiction of this court. The provision is expansive and wide enough as to encapsulate anything coming within the employment and labor relations. It is my view that the claims of the claimant's case is within the subject matter of the exclusive jurisdiction of this court. I have come to this conclusion after having careful consideration of the originating process commencing this suit, which clearly disclose the facts of this case to be within the purview of Section 254C1 of the Constitution as amended. The Supreme Court has extensively considered jurisdiction of this court in the case of Skybank versus U, reported in 2017 LPLR 42595 SC. The argument of the second to post-defendant counsel boils down to the scope of the jurisdiction of the court in labor matters and all relation between employer and employee. The jurisdiction of National Industrial Court will be essentially found in the provisions of Section 254C of the Constitution as amended and Section 7 of the National Industrial Code. The provision has conferred exclusive jurisdiction of this court to the exclusion of any other court in labor and employment relation or any dispute connected to or incidental to the issue of labor and employment or wages of employee. It is clear from the above jurisdiction of this court, it extends to all matters related to, incidental to, or connected with any labor employment dispute in effect. Therefore, an exclusive jurisdiction extends to matters having nexus, intricably linked, or reasonably connected to the subject matter over which jurisdiction is conferred in Section 254C. Therefore, the issue of demotion, the issue of authenticity of result, which led to the demotion of the claimant, is connected, has nexus with the issue of employment of the claimant. In the circumstances, this court has jurisdiction. I hereby found and hold. It is, see also the case of Akwaji versus Omar Sufra. It is clear to me that the main issue which is on the motion of the claimant is within the subject matter of this jurisdiction of this court. This means the objection on jurisdiction failed and same is hereby refused. Coming to the main issue for determination, the law is tried, claim before the court is circumscribed by the relief sought, and the duty of the court is to the duty of the claimant is to adduce cogent and credible evidence in proof of the claim before the court, as the claim may be granted in total or partially granted, but No relief which has not been claimed can be granted, or more than what was claimed. See Gabriel Atibi versus Kabel Metal Nigeria Limited. It is pertinent to point out here that the first defendant, despite having been served with the originating process commencing this suit, and despite the fact that the first defendant was represented by counsel, it, however, failed and neglected to file defense to the claim of the claimant in order to controvert or contradict the pleading of the claimant. The legal and natural consequences of first defendant's refusal or failure to file defense to the claimant's claim simply means, by the ordinary rule of pleading, issues have not been joined, as the allegation are taken to have been admitted and stand unchallenged. The failure by the first defendant to file statement of defense in answer to the pleading of the claimant, the first defendant is in law deemed to have admitted the case of the claimant and will be entitled to judgment. However, it must be pointed out that it is not in all cases where defendant has failed to file a defense that the claimant would be entitled to judgment against the defendant. The peculiar facts of the case are determining factors to be taken into consideration by the court. A court should not enter judgment in default of defense where there is claim for damages, as in this case. Although it is the rule of pleading which is not denied, it is deemed to have been admitted. This means where a claimant files statement of facts and the defendant did not file statement of defense in answer thereto, he clearly will be deemed to have admitted the statement of claim, leaving the trial court with authority to preemptorily enter judgment for the claimant without hearing evidence. However, in law, to every general rule there is exception. The exception to this rule is where the claimant seek for declaratory reliefs, as these are never granted on the basis of admission or default of defense. See Okereke versus Umahi. See also Nison versus Peter Sai, and Bullet International Nigeria Limited versus Dr. Omonike Olani. Another. It is also tried to note that for award of damages, the onus is on the claimant to prove his entitlement to such damages by adducing cogent and credible evidence in support of such claim. See Imana versus Robinson. See also Umana versus Okwerewe. See Oloro Tumi versus Felicia. See also Engineer Pemi Sonuga and another versus Ministry of Federal Capital Territory. See also Bernard Okoibo versus Police Service Commission. The claimant's case being for declaration and damages, he must succeed on the strength of his case and not on the weakness or admission of the defendant. From the claim before the court, reliefs A, B, C, and D are for declaration. The claimants by this is praying for court for declaration, restoring him back to his position. By relief E, claimant is seeking for reinstatement to his original position. By relief G, the claimant is seeking for payment of damage, is payment of 30 million naira for trauma and physical The law is tried for a claimant to be entitled to declaration. He must succeed on the strength of his evidence and not on the weakness or admission. For a claimant to be granted declaration by the court, he must convince the court that he is entitled to declaration in the fullest sense of the word. The claimant will succeed by adducing cogent, credible evidence. The counsel for the first defendant has insisted that claimant is not entitled to the relief sought because he has not adduced any cogent and compelling evidence to entitle him to the grant of the relief sought. In addition, counsel for the first defendant has also insisted that CW1 has given contradictory evidence when under cross-examination has stated the promotion was conducted in 2018 and he participated and was promoted to grade level 17 to grade level 12. This testimony seems to have rendered his pleading where he averred that since his demotion in 2017, he has remained stagnant. This contradicts his written statement of oath and amount to discrepancy. And if it is material, the witness will not be treated as a witness of truth. See Degash versus Vulama. It is also true that no witness who has given evidence on oath through inconsistent evidence is entitled to the honor of credibility and should not be treated as witness of truth. See Abatan versus Audu. This means that CW1 having stated in cross-examination that the first defendant has conducted promotion exercise and he participated and was promoted from level 9 to grade level 12 is in contradiction to the pleading and his evidence in chief that since his demotion to date, he has remained stagnant and he has not to be restored to his position. This entitles him to be believed. It is then for the court to consider other pieces of evidence or record be in the mind issue on declaration whether it is grantable to the discretion of the court. Upon being satisfied of entitlement to declaration, this means if there is other evidence to prove his case, claimant will get judgment. See Salisu versus Mobolaji. It needs to be emphasized that the duty of court is to decide between the parties on the basis of what has been demonstrated, tested, canvassed, and argued in court. It is not the duty of the court to do cloistered justice by making an inquiry into the case outside the court, even if such inquiry is limited to examination of documents which were in evidence when the document had not been examined in court, and their examination out of court disclosed matters that had not been brought out or exposed to the test in court, and were not such matters that at least must have been noticed in court. It is elementary law that contradiction in evidence of a witness that will be patterned must relate to material facts and be substantial. It must deal with the real substance of a case. Minor or trivial contradiction do not affect the credibility of witness and cannot be shared the case of a party. See Pama Kinwa versus the state. See also Musa versus state. See also Regu versus the state. See also Odani versus the state. However, whether or not the contradiction in evidence of a witness is material must depend on the facts of each case. In the instant case, CW1 admitted under cross-examination that first defendant did promote him to grade level 12. This contradicted his evidence in the witness statement on oath, which was adopted as his evidence. This casted doubt on his claim on being stagnant on the position to which he was demoted to death. The contradiction in the testimony of CW1 is fatal to his case, more particularly when considering the fact that he has full knowledge of his case. The contradiction is material and fundamental in that it states the opposite of what was stated in the pleading and witness statement on oath by the witness, which he has adapted in the course of the trial as is evident in this case. This kind of contradiction or difference in evidence could not be consistent with a truthful witness. See the case of Ezekiel Seli versus Onwubu. See also Ele versus Anyadike. See also Salau versus Yusuf. See also Adu versus Badomasi. And Bako and another versus Audu and another. The contradictory evidence of the claimant goes to show that the claimant is not consistent in prosecuting, in presentation of his case. It is really not in the nature or feature of law to approbate and reprobate. A party cannot be allowed to approbate and reprobate at the same time on the same point or issue. See the case of Adeosun versus Governor of Ekiti State. He must be consistent in the manner he built his case and in providing same, improving same. He cannot be permitted to, in giving evidence under cross-examination, to depart from the foundation of his case, either at pleading or in giving evidence in chief. At all times, the party must be consistent in stating his case and consistent in proving it. The Apex Court deprecate this attitude of inconsistency in the case. See the case of Garua Fina versus Ajafa Mai Angwa. For Galinje JSC as his was. The claimant, having contradicted himself, has rendered his evidence unreliable. From the reliefs being sought, the gross of the claimant against the second, third, and fourth defendant is that their response, as contained in Exhibit D2, led to the demotion of the claimant from 2017 to date. The second, third, fourth defendants were negligent in not giving the first defendant correct information regarding the inquiry made on authenticity of his result. The defendant did not deny issuance of Exhibit D2, but maintained that they were not negligent, as the error was as a result of oversight of supplementary approval list, and despite letters Exhibit D3, 4, 5, and 7 written to the first defendant, the first defendant has refused to do anything regarding the case of the claimant. The contradictory evidence of the claimant goes to show that the claimant is not consistent in presentation of his case. It is really not in the nature the claimant having given contradictory evidence, his evidence is hereby discountenanced, as it cannot be given any evidential value. For the second to third defendant, the pleadings and evidence before the court, the grounds of the claimant borders on their negligence. The excuse given is that the error was made due to oversight. Given the facts as disclosed by the pleading and evidence adduced before the court, I'm not convinced that the second, third, and fourth defendant were not negligent in handling the claimant's case. The second defendant, as institution of higher learning, cannot genuinely tag result as forged and fake before making sure all diligence checks have been done to ensure correct information are released regarding the claimant case. They cannot claim ignorance. They cannot claim ignorance of existence of supplementary lists, so it is not an oversight as a claim. However, the claimant's evidence under cross-examination, which had been reproduced in this judgment to the effect that after his demotion, the first defendant conducted promotion exercise which he participated, at the end of which he was promoted from grade level 9 to grade level 12, clearly goes to knock off the bottom of the claimant's case that since his demotion, he remained stagnant since 2017 to date and has not been reinstated back to his position. Restored, he cannot be believed in the face of the contradiction in his evidence before the court under cross-examination. It is to be noted that the claimant, by his own evidence under cross-examination, he was demoted in 2017, and in 2018, he participated in promotion exercise where he was promoted from grade level 9 to grade level 12, which is position even above the position to which he was before his demotion. In view of this evidence, the claimant has not lost anything, as he is now on a higher position by his promotion to grade level 17. So he is on a higher position with his promotion to grade level 12. From all I have been saying above, the claimant has widely failed to make any case to warrant grant of the reliefs being sought, as he has not convinced the court of entitlement to any declaration, which are the main reliefs he sought. The ancillary reliefs must also fail with the failure of the main reliefs before
This one has lost.
having found the claimant's case not meritorious, same is hereby dismissed. I make no order as to cost. Judgment is hereby entered accordingly.
As the court please.
As the court places. We are very grateful, my lord, sir.
My lord, we are very grateful.
Call the next case.
Suit number NIC 2022 between Adoga Elizabeth Omo and 1 Cross River State Universal Education Board, SUBEB, 2 Federal College of Education, Obodo, 3 Provost, Federal College of Education, Obodo, 4 Registrar / Secretary to Council, Federal College of Education, Obodo. My lord, the parties are absent.
Yes, appearance.
If my lord be pleased, may GEOT announce his appearance for the claimant. We sincerely apologize for his absence.
Yes. Yes.
May it please this honorable court. T.O. Inyambe, Senior State Counsel 2. With me is UK Okpan, State Counsel 2. Our humble appearance is for the first defendant.
Yes.
We respect, my lord, sir. ROS
Yes.
Ogbeche. ROS Ogbeche,
Yes.
which means my learned friend, Tony Ode Esquire, for the second, third, and fourth defendants, my lords.
Yes, this matter is for judgment. The judgment is ready. So I don't know, counsel, whether to read the whole judgment or to read the decision portion.
My noble lord, the claimant counsel will have appreciate if my lord read the whole judgment to enable us appreciate just what my lord has did in the first judgment, my lord.
Okay, you want the whole judgment to be read.
Okay.
Counsel, you want the whole.
My lord, you can.
whole
Okay,
judgment
my lord can go ahead and give the judgment. We get the copy after the judgment of my lord. My lord can go ahead and centered it on the judgment, my lord. So judgment orders.
My lord, I believe my learned friend is trying to say that the court can focus on the decision, the finding of the court.
Okay.
Yes, my lord. Thank you, my lord.
The same from second, third, and fourth defendant, my lord.
Okay. Okay.
See ya. You read the whole thing. Yeah, it was spoiling matter. No, but he hasn't said the truth. Is the truth? He didn't tell you. Okay. This particular guy has been reluctant to continue with this case. Yeah. Was it inside? Was it there?
Yes, this is the decision of the court. I have carefully perused the processes filed by the parties and evidence laid at the trial, as well as the oral and written submissions of counsel. The facts that led to the institution of this case are straightforward and not in dispute. The claimant was employed by the first dependent on salary grade level 6, step 1, as a classroom teacher. The claimant rose to the position of senior mistress salary grade level 10, step 11. The position held by the claimant till her demotion to grade level 4, step 5, as per Exhibit C6. According to the claimant, as at 2016, she earned salary in the sum of 78,291 naira. In 2017, the first dependent carried out staff screening exercise among other things, ascertain the authenticity of credentials submitted by the staff. Consequently, the first dependent wrote to the second dependent by the Exhibit D1, later forwarding the 36 names for confirmation of their authenticity of their result. In its reply, the second defendant by the Exhibit D2 confirmed 17 of the result as genuine, while 19 others were stated to have been forged, and the claimant's result fell in the 19 declared forged. See Exhibit C1 and C Exhibit D1 and D2. The first dependent acted on the reply from the second dependent and demoted the claimant to salary grade level 4, step 5. However, upon being demoted based on the reply of the second dependent on authenticity of her result, the claimant complained to the second dependent, and an investigation was conducted, and it was discovered that the claimant's result was not forged. Another letter was written to the first dependent intimating it of the finding of the second dependent and confirming the authenticity of the claimant's result. Despite several letters written by the second dependent to the first dependent confirming authenticity of claimant result, the first dependent has failed and refused to act on the letters from the second dependent stating the correct positions of the claimant result. See Exhibit D3, D4, D5, D6, and D7. The first dependent did not deem it necessary to file any defense to the claimant's action, while the second to fourth dependent have filed their defense declaring the claimant result forged due to oversight of approved supplementary result of 1999-2000 year of graduation. The oversight arose as claimant was supposed to graduate in 1997, but has several carryover courses. This led to error of declaring her statement of result as forged. This, according to counsel, was admitted by the claimant under cross-examination. According to the defendants, the error of declaring the claimant result is a mistake of the heart and not of the mind, as admitted by the claimant in statement of materials part, paragraph 14 and exhibit C9 refers to in support. Counsel submitted because of the claimant's claim and testimony as well as exhibit C9, the declaration of claimant result aspect is not due to negligence but error of judgment. The claimant has argued that since she is entitled to judgment and grant of her reliefs as she had discharged the burden imposed on her by the law when the first defendant has not filed any defense and is deemed to have admitted the case of the claimant. The first defendant on its part has argued, taking into consideration the reliefs being sought are declaratory in nature, which require proof of by cogent and credible evidence and not admission or failure to file defense. The claimant has not discharged the burden of proof imposed on him by law. The first defendant urged the court to dismiss the claim of the claimant against it. The second to fourth defendant insisted that they were not negligent in handling the claimants in declaring claimant result as forged, as that was as a result of claimants having many carry-over causes. The claimant has instituted this action to seek for restoration of her position and payment of balance of her salary due to the shortfall occasioned by her demotion. In my view, the issue that calls for resolution is whether the claimant has proved entitlement to any of the relief sought. However, before delving into the main issue for determination, I shall first and foremost determine issue of jurisdiction raised by the second to fourth defendant in their argument. In arguing the issue, ROS of Beche Esquire, counsel for the second, third, and fourth defendant, submitted that this court lack jurisdiction to entertain this should have a regard to section 7 and 254C of the Constitution as the endorsement of the claim against the second defendant is not within the purview of the jurisdiction of this court. Counsel urged the court to strike out the suit against the second, third, and fourth defendant. For the claimant, it is submitted that the causal connection of the demotion was the sole act of the second to fourth defendant, though their reply to Exhibit D1 by the Exhibit D2 was the source or cause of the claimant's predicament, which resulted in being demoted. The second to fourth defendant response in paragraphs in paragraph 4, 6, 7, 8, 9, 10, 11, 12, 13, 16, and 17 of the joint statement also amount to admission and passing back to the first defendant. They are admitted, however, to be originators of the impasse. That is the course of action before this court establishing the case. Counsel asked the court to hold that it has jurisdiction to entertain this matter. It is clear to me, counsel for the second to fourth dependent argument on jurisdiction is predicated on employer-employee relationship. This assumption is based on the great consumption of law that it is only when there is employer-employee relationship that this court has jurisdiction. In any event, if no jurisdiction is conferred by law, establishing the court in question and the Constitution, the National Industrial Code of Nigeria being creator of the statute and the Constitution had its jurisdiction delineated by the statute and Constitution to successfully determine whether the National Industrial Code has jurisdiction to entertain this recourse has to be made to the provisions of the statute and Constitution. A reference here is made to section 7.1 and 254C of the Constitution, where the court has been conferred or closed with exclusive jurisdiction to entertain civil matters and causes on employment and other related or connected matters or any matter connected with labor and employment. In the case at hand, the parts of this case center on the motion of the claimant, which was as a result of response of the second defendant as contained in Exhibit D2, tagging the result of the claimant as forged. I am of the view that determination of propriety or otherwise of Exhibit 2, which was used to demote the claimant, is an issue relating to or connected to with employment dispute, which is within the purview of the provision of Section 254C1 of the Constitution of Nigeria. It is to be noted that the provision of Section 254, as amended, has brought all aspects of employment and labor relations within the jurisdiction of this court. The provision is expansive and wide enough to encapsulate anything coming within the employment and labor relation. It is my view that claimant case is within the subject matter of the exclusive jurisdiction of the National Industrial Court. I have come to this conclusion after careful perusal of the originating processes commencing this suit. I was which clearly disclose the facts of this case to be within the purview of Section 254C1 as amended. The see also the case of Skybank versus you. The argument of the second to third to fourth dependent counsel boils down to scope of the jurisdiction of the court. The jurisdiction of the court as encapsulated in Section 254C1 of the Constitution as amended and Section 7 of the National Industrial Act are clear and unambiguous, and they have conferred on this court expansive jurisdiction in relation to labor. It is clear from the above that the jurisdiction of extent to all matters related to incidental thereto or connected there with labor and employment dispute. In the circumstances, the issue of declaring the result fake is an issue that is connected or has nexus to the issue of employment of the claimant. It is therefore within the purview of the provision of Section 254C1 of the Constitution. Therefore, the broad power of the National Industrial Court to exercise jurisdiction vested in it and in every cause or matter will come to play in this case. And I hereby found and hold that this court has jurisdiction to entertain this case. It is clear to me the main issue on the which is on the motion is within the subject matter of jurisdiction of this court, which is an employment issue. This means the objection to jurisdiction failed and same is hereby refused. Coming to the main determination of the suit, the law is right that claims are circumscribed by the relief sought, and the duty of the claimant is to adduce cogent and compelling evidence in proof of his case, at the end of which he may get all the reliefs granted or partially granted, but not granted those that has not been claimed. It is pertinent to point out here that the defense defendant, despite having been served with the originating process commencing this suit, did not file memorandum of appearance or enter or file defense to the claim of the claimant. The legal consequences of the first dependent refusal to file defense is that it is deemed by law to have admitted the case of the claimant and the claimant will be entitled to judgment. However, it must be pointed out that it is not in all cases where defendant has failed to file defense that the claimant will be entitled to judgment against the defendant. The peculiar facts of the case are the determining factor to be considered into consideration by the court. A court should not enter judgment in default of defense where there is claim for damages, as in this case, or where the reliefs being sought are for declarations. Declarations are not granted as a matter of course. It must be proved. The claimant must prove entitlement to the declaration to the fullest. By law, a claimant seeking for declaratory relief must prove his case on the strength of his evidence, not on the weakness of the defense or defendant, on the weakness or failure to file defense. See Okereke Umahi and other cases cited therein. It is also tried law that for award of damages, the onus is on the defendant to prove his entitlement to such damages by adducing cogent, credible evidence to support his claim. See the case of Imana versus Robinson and others cases cited therein. The claimant's case being for declaration and damages must succeed on the strength of his case and not on admission or failure to file defense. From the claim before the court, reliefs A, B, C, D are for declarations. The claimants by this reliefs is praying the court for declaration respecting her demotion and the restoring her back to her position. By reliefs E, claimant is seeking reinstatement of her original position and payment of entitlements and benefit she would have earned, but for her purported and tainted information given to the first defendant. By reliefs F, the claimant is seeking for payment of the sum of 30 million naira only for physical torture and pains and financial degradation for upward up to 5 years from 2017 to 2022. By relief G, claimant is praying for payment of the sum of 1,500,000 naira as cost of this action. The law is right that the claimant to be entitled to declaration, she must succeed on the strength of her evidence and not on the weakness or admission of the defendant. For the claimant to be granted declaration by court, she must convince the court of her entitlement to the declaration in the fullest of the sense of the word. The claimant would succeed by adducing cogent and compelling evidence. The counsel for the first defendant has insisted that the claimant is not entitled to the relief sought because she has not adduced cogent and compelling evidence to entitle her to be granted her reliefs. Yes. For the second, third, and fourth defendant, from the pleadings and evidence before the court, the grounds of the claimant is that the second to fourth defendant are negligent in giving the first defendant wrong and false information regarding the authenticity of claimant result, which resulted in his demotion by the first defendant. The excuse given by the second to fourth defendant is that they were not negligent, as immediately the error was discovered, steps were taken for corrections. They relied on Exhibit D3, D4, D5, D6, and D7 on their effort in informing the first defendant of the corrections of the claimant's result, and that the error was due to carryover courses the claimant had which made her not to graduate within the time. Given the facts as disclosed in the pleading and evidence adduced before the court, I am convinced that the second to fourth defendants were not negligent in handling, I'm not convinced that the second to fourth defendant were not negligent in handling the claimant's case. The second defendant, as institution of higher learning, cannot genuinely tag result as forged and false before making sure that all diligent checks and the balances have been conducted to ensure correct information are released regarding the claimant's result. There is no doubt that dependent from their day-to-day activities are very well aware that there is always original and supplementary list for graduates. And when the first defendant requested for the verification, they only went to check the original or main list, leaving out or ignoring the supplementary list. If the defendant have diligently done their job by checking both the original and supplementary list, the issue of tagging claimant's result as forged would not have arisen. I am convinced that the defendants were negligent in tagging claimants' result as forged without making proper inquiry by checking both the original and supplementary list. In the circumstances, the claimant has succeeded in proving that the defendant were wrong in their judgment, and they must bear the consequences of their action. The first defendant based its action in demoting the claimant based on Exhibit D2, which tagged claimant's result as forged. However, the second defendant, upon conducting proper investigation, discovered that it was wrong in declaring claimant's result certificate forged. This was after examining the supplementary list of approved results. The finding of the second defendant was conveyed to the first defendant, but it failed and neglected to restore the claimants back to her position prior to demotion. This was despite Exhibit D3, D4, D5, D6, and D7, which was letters from the second defendant intimating first defendant of the mistake made in issuance of Exhibit D2. But the first defendant, despite all efforts made to make it see reason to change its position, remained adamant and unconcerned about the claimant's plight or predicament. To my mind, it is clear. To my mind, the action of the first defendant amount to sheer wickedness and inhumanity. If the first defendant can act swiftly on Exhibit D2, what stopped it from acting in the same way and manner it acted when Exhibit D2 was submitted to it? Exhibit D3, Exhibit C5, D3, D4, D5, D6, and D7 were brought to the attention of the first defendant. And the first defendant has even acknowledged receipt of Exhibit C5 and also even demanded further clarification, which the second defendant has obliged it and replied and clarified the issue. It is unfortunate, despite confirmation of Exhibit C5 that it emanated from the second defendant, the first defendant refused and neglected to act to restore claimant's position and salary. The second, third, and fourth defendants have argued that they are not to be blamed for the voice of the claimant in demoting her. This position is based on misconception. Exhibit C6 has made it very clear that the cause of the action taken by the first defendant in demoting claimant was Exhibit D2, where the second defendant tagged claimant's result stroke certificate forged. The issue of admission of crime is of no moment. As there was no evidence to the type of crime that was committed, which was said to have been admitted by the claimant, which would have warranted the defendant to demote her and refuse to prosecute her. After all, the prosecution the first dependent does not have power to prosecute anybody or person. It is the police that has such powers to investigate, and if a person investigated is found to have committed a criminal offense, that person would be charged to court. There has been no any investigation to indict the claimant of any criminality. In the circumstances, Exhibit C6 cannot be proof of commission of any crime by the claimant. The first defendant who was to throw more light on the issue has failed and refused and neglected to file defense in this matter. The court is left with only the evidence as adduced by the claimant and that of the second, third, and fourth dependent. From all I have been saying above, the claimant has been able to establish the motion was wrongful as it was based on misinformation from the second dependent. The claimant ought not to have been demoted, and she ought to have been restored back to her position before her demotion. But the first dependent remained recalcitrant and refused to heed to all entreaties to accept the corrections made by the second dependent to restore the positions of the claimant prior to her demotion. It is clear to me that from the evidence before me, the second, third, fourth dependent have breached duty of care to make available to the first dependent correct information regarding claimant's result. It is the second, third, and fourth dependent that caused the claimant to be in the position she found herself. The claimant is therefore entitled to be reinstated back to her position prior to her demotion. In the circumstances, I hereby order that the claimant should be restored back to her position and her salary grade level shall also be restored. On the issue of payment of entitlement, the claim of the claimant, as shown by relief E, is vague in the sense that she has not been able to prove her correct salary and also the shortfall which she has lost and has not claimed any quantum before the court. By the case of Dr. Ikogo versus University of Jos, the relief sought regarding the entitlement or payment of shortfall has not been proved. The claimant relief is vague and cannot be granted in the way it was couched. On the claim for 30 million naira, the claimant has been able to show that the dependents, the second, third, and fourth dependent were negligent in performing their duty by causing the dependent to have been demoted for a period of 5 years. In the circumstances, the claimant is entitled to compensation from the second, third, and fourth dependent, and such will serve as deterrent for them to be diligent in carrying out their function. In the circumstances, I award 5 million naira in favor of the claimant for for the negligence of the second, third, and fourth defendant in making her to be demoted from grade level 10, step 11 to grade level 4, step 5. The claimant is also entitled to cost of this action, which are assessed in the sum of 500,000 naira. All monetary aspect of this judgment must be paid within 30 days from today, failing which 10% interest shall apply. Judgment is hereby entered accordingly. Yes. Yes. Registrar. Registrar. Yes, counsel, you can unmute yourself. You have muted yourself.
Okay, we are very grateful, my lord, sir. We appreciate
welcome.
the judgment. Yeah, okay.
My Lord, the claim on behalf of the claimant, my Lord, we are grateful. We appreciate,
You're
my
welcome.
Lord, judgment.
You are welcome.
Thank you, my lord, sir.
You are welcome.
Yeah.
Registrar, call the next case.
We have. That is this man. The man. That man. That man. I will listen.
I said call the next case. Why are you offline?
I'm trying to log back in. I guess my data is full.
You should have told the divisional registrar to give you money for data or to give you data. Have you not told her?
No, my lord, I did not.
Why?
Lord, I'm sorry I didn't know what data. I'm honored to give on this.
Counsel, you should unmute yourself. Counsel, you should unmute yourself. Please, I'm online doing. We are doing virtual sitting. The registrar has gone off. I don't know what is happening.
Okay. Oh, let me go down at all, my lord, and find out.
Have you provided her with data? You're supposed to give her data for this. Whenever we have sitting, you have to provide her with data.
Okay. So she didn't request for data, my lord.
Please, I'm waiting. We are online. Counsel are waiting. Counsel are waiting. I say go and sort out whatever problem is there. Counsel are online. I want to continue with sitting.
All right, my lord, I'll do that, please.
Counsel, I'm sorry, the registrar went offline, so we are waiting for her to rejoin. She's trying to connect back.
As a company, sir.
I hope the witness is online. Dr. Sam Ebo,
Yes, my lord.
is the witness online?
My lord will respect our own is for.
You said?
My lord, there's adoption.
Okay. It's not, I thought it is sharing.
No, yes, my lord,
Call,
it's for adoption.
call the
And
case, call the case.
yes, my lord.
Call
Suit
the
number
case.
CN CA 52 2023 between Akpan Sin Ekong Akpan and ECM Terminal Limited. My lord, the parties are absent.
Okay.
Yes, my lord.
Registrar. Tell them to unmute themselves. Dr. Sam Ebo, please unmute yourself. Mr. Etim Yang, unmute yourself. Hello?
Hello, they are there. I've spoken with them.
But they have not unmuted themselves. I can't hear them. You too, I cannot hear you. All of you have muted yourself.
Yes, I muted myself because the head of division came and asked what happened.
And now tell them, let them unmute themselves. And Dr. Ebo, she has muted himself again.
Okay.
Call them, let them unmute themselves.
Let me tell him to unmute himself. Maybe they don't know.
Please, counsel, unmute yourself. Counsel, unmute yourself so that I can hear you.
My Lord, with respect, can you hear me, sir?
Yes, I can hear you now. Yes, go ahead and announce appearance. Yes, Dr. Sam Ebo. Hello. Yes. Go ahead and announce appearance. Etim Inyang, you must unmute yourself. You must unmute yourself for you to be heard. I can't hear you.
The video.
You too, I say you should call them and tell them they have muted themselves and
My
unless
Lord,
they unmute.
I have.
Yes?
I've been calling doctor. Doctor is not taking. Mr. Yang too. Is not taking his call.
Yes, doctor. Dr. Sam Ebo, you have muted yourself again. Please, you have to unmute yourself. Check your system and unmute yourself.
Sorry, my Lord, can you hear me now? With due respect?
Yes, yes.
I appreciate,
Go ahead
my Lord,
and announce
respect.
appearance.
My Lord, my appearance, Dr. Sam, my appearance is for the claimant who is here with me. Come
Yes.
on, let me see.
Mr. Inyang, unmute yourself and announce your appearance, please. Mr. Inyang, unmute yourself and announce your appearance. I don't know.
I think he's having a slight problem, sir. I don't know.
He is not
He
having
called
any
me.
problem. He muted himself. He has to unmute himself. He has to go to the
Very well.
microphone and press it.
Very well, my Lord. Very well, my Lord. That's what I did, sir.
Because I can't hear him. Nobody will hear him with the muting of himself.
Etiminyang, are you there?
He can hear you, but you can't hear him because he has muted himself.
Oh my God.
Mr.
He called me that he was.
Please unmute yourself.
Oh, problem.
Mr. Inyang, unmute yourself, please. Hello, Mr. Inyang. Unmute yourself and announce appearance.
My respect, I think he went off. Sorry.
He has gone off now.
Yes, my Lord. That's the comment. He called me that he had that problem. That he was trying to join the meeting.
Once he unmutes himself, we will hear him. There is no problem. Maybe he doesn't know how to unmute himself. I'm sure that is what is happening. He doesn't know how to unmute himself. Please, can you put a call to him so that to know whether he's or we proceed with the business of the day.
My Lord is battling with it. He called me. That he suddenly went off. I'm sure he's battling with it.
Okay.
So I don't know. My Lord, just some minutes. Let me see whether I can get back to him, sir.
He is back now and he has unmuted himself. He has muted himself. He's back online. He has muted himself.
Okay.
My Lord, I was with him. I was telling him what. I was calling him. I'm telling him what to do. So I don't know. He said he's alone in the chamber, so he doesn't understand where to press. I've tried explaining that if you touch the screen, all those things will come up and he will.
And if he touches the screen, he will see it. He will see the microphone. It will even show him mute. Then he will touch it. He will also see the video.
Correct.
Once he touches
that's
the screen,
correct, sir.
Everything will come out. Mr.
That's
Enyang,
correct.
touch your screen. Touch your screen and unmute and unmute yourself. Mr. Enyang, touch your screen and unmute yourself. I don't know how.
If it doesn't go now, then he will. Okay, and if we don't adopt, we can't go for 10 minutes. So we must surely do so. Say something.
What we will do is let me join with another device. Then I will show it to him practically. Maybe he will get it.
That's fine.
Aji. Hello, Etiminyang. Hello.
Yeah, Mr.
What's your problem?
Mr. Ian, look at me now.
Are you back online? Are you back online, Inyang? We can't hear you. My Lord is trying to hear you.
No, let him look at me. I'm going to show him how he will unmute.
Please just look at my Lord.
You just touch your screen.
Just try and see if you can unmute yourself.
Once you do it, this one will come out. You press it.
Etim.
Have you seen it? Mr. Ian.
Are you seeing me?
You just touch your
screen. You will see it.
It will pop up and you see it.
Hello? The problem is we don't know whether he's device.
Mr. Ian.
Mr. Ian.
Well, he can give us go ahead.
We can't continue to be waiting for him. Let's make progress. Yes, Dr. Sam.
Yes, my Lord. My Lord, the defendant filed his written final address. His written final address on the 17th of March, 2025.
17th of March.
17th March,
yes.
2025, sir.
Yes.
My Lord, claimant, in response to that, filed his written address on the 19th of March, 2025.
Yes.
Defendant in response to that, 5 points of reply on points of law on the 2nd of April, 2025.
Yes.
My Lord, the claimant adopts. My Lord, claimant adopts the argument in his written address as a submission to this matter. And urge your lordship with respect to grant the claims of the claimant.
Yes.
My Lord, I don't know with this situation whether I can just do 1 or 2 ways, not really adumbration. I don't know, given the situation he is now.
Yes.
I don't.
Yes.
Yes, just a few clarifications. Let me just make a few clarifications, sir.
Yes.
Yes, sir. My Lord, first, the defendant's written address on is incompetent on the grounds that is full of facts. He tried to re-argue his matter. I would have pointed out 1 or 2 paragraphs, but my Lord, let me waste your time.
Yes.
My Lord, certainly, in the replies, he tried to distinguish between termination and dismissal. Very, very important. That's where he argued it. He tried to distinguish between termination and dismissal.
He failed
Stating
to
that
distinguish.
between
Are you saying he
termination,
failed to distinguish?
he distinguished between termination and dismissal,
Okay.
and that is required.
Okay.
He said the claimant was dismissed. That
Okay.
was argument.
Okay.
Yes, and my Lord, let me just refer you to a document that will help you so that we don't waste your time.
Yes.
If you look at the termination letter, I think that's 2016.
Yes.
It was clearly stated entirely.
Yes.
Why is stated instead that the claimant appointment was terminated because of poor culture of it and specific requirements that so it's
Yes.
Section 624 of
Yes.
the manual. Yes, my lord. So that's very important. That's what he was trying to. Finally, sir.
Yes.
So that we don't waste your time.
Yes.
The final thing was the issue of notice. What the
The
claimant
issue
was
of what?
paid 1 month notice salary, 1 month.
Okay. Salary. Yes.
They claiming to paid it.
Yes.
Salary for the 1 month.
Yes.
When the claimant was on. Yes, sir. That was what was paid. And even at that, sir, we do respect. What
It's all right.
after the was not 1 month. You have clearly stated that it wasn't. Because if you look at it, if you look at it, upper review, gotten the upper review is there, and the one day which they tendered, we surely the claimant salary was as base salary. So there was no one more.
Yes, Mr. Ebo, what will happen? What will happen to the address of the defendant? What will happen to the address of the defendant and the reply?
What will happen? Your lordship will invoke the rule. Your lordship will invoke is it for adoption? 45 rule 7. I hope I'm still on.
Yes.
Yes, my lord. These are just vital issues. I just wanted your lordship with respect to take a critical look on. Yes, sir. Yes, sir.
Okay.
I with my colleague, he was struggling to come up.
He's still there.
My lord,
he's still there, but he has muted himself, but he is hearing the conversation.
I think so. I really sympathize, but I don't think much
he's
damage.
hearing the conversation. It's only that we can't hear him because he has muted himself. So until he unmutes himself, we can't hear him. Yes, I will give you that for judgment.
As the court pleases.
Yes, okay, sir. As the court pleases, sir. Date. Vicky, I don't know.
Sir?
Registrar,
Date.
Check June. June, do we have any judgment 3rd week of June?
My Lord, I'm checking.
Okay.
No, my Lord, no judgment in third week of June.
Okay. I think 21st is Thursday. June 21, is it Thursday?
No, 21 is a Sunday, my Lord, in June.
Yeah.
Yes, my
21.
Lord. Yes, my Lord. It's a Saturday. Sorry, my Lord. Saturday
Okay.
in June. Saturday. Yes, my Lord.
Okay, 19 will be Thursday.
Yes, 19 is a Thursday, my Lord.
Okay. This case is hereby adjourned to 19th of June 2025 for judgment.
As the court pleases.
As the court. My Lord, we really appreciate, sir.
You are welcome. So you communicate to him. Also, I know he is hearing us.
Yes, I'm going to call him. He hasn't suffered any.
Okay.
There's nothing, no problem in it.
Yes. Registrar, any other matter?
No, my Lord, that's all for today.
Okay, thank you, counsel, for being with us. We have come to the end of today's
Very well.
proceedings. The court will. Administrator, you can discontinue with the sitting.
Thank you, my Lord.
Thank you.